Good evening, and thank you for tuning in. ELI at 10, European Law Institute, 10 years on. This is a webinar on the rescue of business in Europe, with the title also, The Impacts of ELI's Work. My name is Bob Wessels. I'm an emeritus professor at Leiden University in the Netherlands. And together with my colleague, Professor Stefan Madaus, University of Halle-Wittenberg, in Germany, we worked for some 4 years on our report of rescue of business in Europe. In our work, we were assisted by Gert-Jan Boon from the University of Leiden and around 45 European advisors and correspondents. Tonight in the panel, you also see other faces. Hélène Bourboulou. She's an insolvency practitioner from Neuilly-sur-Seine, which is very close to Paris, and Professor Irward Maverick, Professor of International Commercial Law of the University of Nottingham in England, Andres Martinez from the World Bank in Washington, and Alexander Zadorozhny, an attorney from Moscow in Russia. They will be further introduced by Stefan and Gert-Jan during the session, which are moderated by each of them. Now, the Rescue of Business project, as we called it. Our European Law Institute study sought to design elements of a legal framework that enables further development of coherent and functional rules with regard to business rescue in Europe. This would include statutory procedures that could better enable parties to negotiate solutions when a business becomes financially distressed. But such a framework should also include rules to determine in which procedures and under which conditions an enforceable solution can be imposed on creditors and other stakeholders despite their lack of consent, so against their will. Our project had a broad scope and extended to consider frameworks that can be used by non-financial business out of court and in a pre-insolvency context. Well, the result of all the work is what the European Law Institute calls an instrument, an independent proposal addressed to the European legislator and national legislator and the restructuring community. The project also includes national inventory reports from 13 countries, normative reports, and an international inventory report with recommendations with regard to business rescue from standard setting organizations like UNCITRAL, the World Bank, or the EBRD, the European Bank for Reconstruction and Development. Our report itself contains 400 pages and was unanimously adopted in September 2017 by the ELI Council and the ELI General Assembly. It is available on the website of the European Law Institute, but also on SSRN, and Gert-Jan Boon will put somewhere in the chat box the link to both of these sites. By the way, this morning I looked at SSRN and there are 970 downloads. The ELI doesn't count the downloads, so there's quite some response on the report. The full research, so the rescue report itself, including all the reports, has been published by the Oxford University Press, Rescue Business Law, at least I can see it, and which was published by the European Law Institute and Oxford University Press in September last year. It has Mind you, 1,434 pages. Now, the core of the business rescue report. We have in all, Stefan and I, 115 recommendations with regard to 10 themes. And the chapters roughly are the following. The first chapter is the actors and the procedural design of the proceedings, the role of a court, the role of a mediator or a supervisor, recommendations for insolvency practitioners, IPs, and for the functioning of a DIP, a debtor in possession, which is a topic that we will discuss later during the webinar. It also contains some conditions for roles by a turnaround manager or by a CRO, a Chief Restructuring Officer. So we welcome specifically academics from company law background or corporate law background to take a look at those paragraphs. Then the other chapters relate to how to finance a rescue, how to deal with executory contracts, the ranking, of course, of creditor claims, a governance role of creditors, labor, benefit, and even pension issues, avoidance of transactions, the sales of the business of a going concern, issues of a rescue plan, the procedure, its structure, the distribution, corporate groups, and then finally, the second topic for the webinar, special arrangement for small and medium-sized enterprises. Okay, the webinar says, well, what's the impact of this research? Well, the impact, and I'm not shy, of course, to say, is that the European Commission has used our report in the preparation of the Preventive Restructuring Directive 2019/1023, and also in its current practice on the enhancing of the convergence of insolvency law. Several issues of the report have been on the table of the European Commission. National legislators have referred to the report, including the English legislator when it launched its Corporate Insolvency Governance Act of 2020. There are, maybe some of you will know, hefty debates in academic literature, especially about so-called absolute priority rule or the relative priority. Italy and Spain and Germany, several authors in the Netherlands have very outspoken ideas about it. And there have been translations made. There's a translation of several parts in German language. I remember Portuguese, I cannot control it. And also, and we are very proud to say so, that it has been translated by a group which was led by Alexander in Russian, which is of major importance because many countries on the eastern side of Europe speak Russian. Well, that's all. Now the agenda, we have two topics chosen: the debtor in possession on the one hand, and the small and medium enterprise on the other hand. And I invite Gert-Jan Boon and later Stefan to introduce the topic and also the speakers. I wish you an enjoyable meeting.
Thank you, Bob, for this introduction. Yes, this first panel will focus on the position and the role of the debtor in possession. In short, we will see references also to the DIP or the DIP. And it's a concept that the EU has already defined to require that in a restructuring or insolvency proceeding, the debtor can continue in possession of its estate, at least partially, in particular with regard to the day-to-day operations. And in addition, this may also allow that the court can still appoint a practitioner, but only on a case-by-case basis. So in general, proceedings that would meet these kind of requirements could be considered a so-called debtor in possession proceeding. In our business rescue report, diving on to the role of actors and in particular DIP, we've also made some notes on what this DIP should be. We in particular noted that it is novel in certain jurisdictions, but also see a great diversity in how this principle is applied in other European countries. The DIP introduces, furthermore, specific intrinsic contradictions. Although it may be efficient to keep the debtor in place, to keep the directors in place, but can we actually trust this debtor to continue while it was at first also the one leading the debtor into financial distress? It is therefore that in our report, we have recommended that there should be, in order to build more trust, a clear duty to timely inform shareholders and other stakeholders to take adequate measures to prevent the financial distress, provide maybe a safe harbor for directors to take restructuring activities, but also, given the great diversity of this principle, maybe dive into further study and analysis what the duties and liabilities of directors should be. We're very, very lucky today to have two experts with us, Hélène Bourboulou and Alexander Zadorozny, who will elaborate on how this principle is or is not yet fully into practice in either France and Russia. I'm very pleased to first welcome Ms. Hélène Bourboulou, a co-founder and managing partner of FHP. It is a firm that provides judicial administrators services in insolvency proceedings all across France. And Hélène too is one of the France 150 judicial administrators who are mandated by the courts to assist companies in difficulty. In addition, she is also teaching at La Sorbonne and has provided an important contribution together with her colleague Sylvain Astin as a national correspondent for France in our ELI Business Rescue project. Hélène, can I give the floor to you?
Thank you. I'm very proud to be with you tonight. Okay, so I tried to give you an overview on the debtor in possession and the French rules in 10 minutes. So please keep in mind only the key feature. First, as Gertjan mentioned, DIP is a fundamental feature of US bankruptcy law, which is not a common concept in Europe. If we just focus on definition, a debtor in possession is a debtor in respect of which insolvency proceedings have been opened, which do not necessarily involve the appointment of an insolvency practitioner or the complete transfer of the rights and duties to administer the debtor's assets to an insolvency practitioner, and where, therefore, the debtor remains totally or at least partially in control of its assets and affairs. What is at stake? On one hand, the existing business of the debtor's directors concerning the debtor's business can continue without disturbances which may be detrimental for the business prospects. On the other hand, leaving a debtor or manager in control of a business that has failed under their management may hinder other stakeholders to trust the restructuring efforts of the debtor. Sometimes, failure is caused by bad management decisions, and we also have to consider that. If we focus on the French view, in France, as in most European member states, a distinction is made between reorganization-oriented proceedings, as amicable proceedings, pre-insolvency proceedings, safeguard or rescue proceedings, and reorganization proceedings. And on the other hand, secondly, liquidation proceedings. In a nutshell, the loss of control of the debtor over his business is directly proportional to the level of difficulties and the level of coercion of the procedure. What it means? It means that the French debtor remains in possession at 100% during the amicable procedures, out-of-court procedures, mostly in safeguard proceedings, depending on the level of the mission of the practitioners that could be appointed by the court. We'll come back later on that. Partially in reorganization proceeding, assistance mission, the most obvious manifestation for small business enterprises managers is the counter signature of payments. That is something very strong. I countersign or not the payments for the business. And 0% of freedom in reorganization proceeding in case of dishonesty or vacancy. Sometimes the manager is so dangerous that the court decide to give me a mission of representation. I have to replace the manager. In any case, in liquidation proceedings, the debtor loses all his power over his estate. Liquidator is then appointed by the court to manage and liquidate the assets. And before liquidation operations, a judicial administrator can be appointed for holding a takeover process. If we focus on the preventive restructuring directive, in the Article 5, debtor in possession, we can read that the preventive restructuring framework in each jurisdiction should ensure especially that debtors accessing preventing restructuring procedures remain totally or at least partially in control of their assets and the day-to-day operation of their business. What is the equivalent in France? Amicable procedures allow debtor to keep full control over his company, and safeguard and reorganization proceedings allows debtor to keep a partial control over its company, where the powers of the debtor are limited for acts exceeding day-to-day activities. There is a control of what is an act, supposing the assistance of someone else or the control or supervision of a judge or an IP. The appointment of a practitioner in the field of restructuring to assist the debtor and creditors in negotiating and drafting the plan, at least in the case where it is requested by the debtor or by a majority of the creditors. Amicable procedures, it means that conciliator and mandataire ad hoc assist the debtor, and in safeguard and reorganization proceeding, the judicial administrator assists the debtor. Regarding the DIP, most important measures of this directive are already in place in France. We were already familiar with those concepts before the directive. If we focus on amicable proceeding, meaning pre-insolvency proceeding, out-of-court procedure, it's not fully out of court because in France, mandat ad hoc and conciliation are opened by the president of the court. But the president of the court is not the court exactly. It is someone specially designed for opening those out-of-court procedures and fully separate of the court in itself. Short presentation, only the debtor can initiate an amicable procedure in France with the possibility to end it whenever he decides. It cannot be imposed by creditors. In the same time, it cannot be imposed to creditors, meaning that if the creditors or lenders do not want to participate to the amicable procedures, they are free to do it. The purpose of this procedure is to facilitate negotiation of an agreement, to make it short. It also means that we are very in advance of an insolvency statement, for instance. Those kind of out of proceedings are completely confidential, mainly amicable. It's a mandat ad hoc proceedings in France, flexible out of court proceeding with no time limit. It can be renewed by the president at any time. Or conciliation proceedings, that is a bit more regulated out of court procedure initiated with a view to an agreement between debtor and creditors. True management tools that allows debtor to remain in possession. I don't develop more because the time is going, but keep in mind that in out of court procedure, the debtor is full debtor in possession. There is, he retains full control over his business. Keep also in mind that those procedures are mainly amicable, but with important exceptions. In some circumstances, there are possibilities for the judge who has opened the procedure to postpone some payment terms with an extension up to years, and to free the capacity for the contracting party to cancel a contract. It has been a new exceptional measures that are being given with the COVID measure. So we do not know exactly if it will last in the time, in the next years, but it is still the case. We can free the capacity to cancel a contract, even if we are in an out of court procedure. And to finish, the conciliation procedure authorizes the debtor to postpone the obligation to file in case of insolvency statement during the whole period of conciliation. And conciliation period can last 5 months, but with exceptional measure for COVID, it can last 10 months. If we focus on safeguard proceedings, rescue proceedings, safeguard proceedings are open in France at the request of a debtor, which can prove that although he is not insolvent, he has difficulties that he is unable to overcome on its own. A procedure which makes it possible to deal with the insurmountable difficulties of a company before the state of suspension of payments by setting up a safeguard plan. The negotiation takes place through 2 creditors committees that will be soon replaced by classes of committee according to the European directive. And the key feature is the collective discipline, meaning that the debtor's liabilities are now frozen, all are frozen, and the creditors who are prohibited from pursuing him individually must declare their claims to the procedure pending a fair payment. Collective disciplines involves coercive measures towards creditors. In counterpart, the debtor remains partially, but only partially, in possession under the supervision or the assistance of the judicial administrator, and more broadly under the control of the court. Debtor retains partial control over his business. So it's a debtor in possession is still in place. In principle, a judicial administrator is appointed by the court, but if the debtor does not reach some threshold, meaning for the smallest company, under 3 million euros of turnover and 20 employees, a judicial administrator is not necessarily appointed, meaning that the debtor remains in full possession of its means under the control of the court directly, and with the intervention of the creditor's representative, because in France you have 2 insolvency practitioners appointed by the court. So even if a judicial administrator is appointed, debtor remains in partial possession. The judicial administrator has to go with the debtor in some circumstances. For instance, in safeguard proceedings, the debtor in partial possession may not perform acts of administration and disposition with respect to the estate without permission or assistance of the administrator, and if needed, the supervisory judge. So to conclude, because time has gone, different levels of control in safeguard proceeding, according to the mission of the administrator in safeguard proceeding, supervisory or assistance, the more serious the acts, the greater the dispossession of the debtor, proportionally between procedures, coercion, and dispossession of the debtor. For acts not related to day-to-day management, but acts that are not acts of disposal, powers of the debtor are different, depending on the judicial administrator mission. It can be supervisory, meaning that the control is coming ex post. It can be assistance, meaning that to order a payment, for instance, the signature of the administrator is required for the validity. And depending also, for some acts, even with the assistance of the administrator, the debtor still need the authorization of the court. So you have different degree of acts in the management. If it's day-to-day, more exceptional, more and more exceptional, you have the assistance of administrator, supervisory judge, or court itself. Finally, the disposition of the debtor is proportional to the level of difficulties and the level of coercion of the proceeding, but also the importance of the acts you need to put and to implement for the rescue proceeding at the end. Thank you for your attention.
Thank you, Hélène. And I must say, this was very interesting, especially to see the very gradual nature of how you've been developing and balancing the different powers of both the debtor and the involved actors, administrators during the different proceedings. For any questions that might have already emerged during your presentation, I would kindly welcome all the attendees just to drop them in the chat. There's a Q&A session at the end where we will return also to questions that are directed at the presentation of Helen for now. For now, we will switch to our second speaker, Mr. Alexander Zadoroshny. Alexander is a partner at Sinem Attorneys, which is based in Moscow, Russia. He has taken also a particular interest already in, also academically, in the area of restructuring and insolvency law, which has also been evidence, I could say, as Bob already mentioned, in the delivery, which was initiated and coordinated by him, of a Russian translation of the ELI instrument on business rescue. And this is particularly helpful for all, I think, the broader realm of Russian-speaking countries, so that they can take a better understanding also of current discussions going on in Europe. But with further ado, I would say I'll hand over to Alexander, and please share with us some insights on how debtor and debtor in possession aspects are a part of Russian law. Thank you.
Mm-hmm. Thank you very much. First of all, I would like to express my special gratitude to the team that prepared the Rescue of Business in Insolvency Law report. I really think that this is a turning point because, as I understand, the scope of materials and analyze of different legal system, it's something, and it is a really big work. So concerning the present topic, the debt in possession, in my point of view, this is one of the key points of restructuring as a whole, because it concerns the party of restructuring procedure. Debtor is a party of this contract of restructuring and all of these relations. But I think that debt in possession is not, of course, is not a simple thing, and this is not always the feature of restructuring. For example, in the present Russian legislation, but I need to say that Russian legislation is in the process of the reform, and maybe in autumn the new law on bankruptcy will be adopted with new procedures. But now, about 30 years, the Russian legislation has the procedure, the insolvency procedure, which is called observation. And this procedure is the very first and the most common procedure in the Russian law. Actually, this procedure is always introduced with some specific exceptions. They relate to when the bankruptcy procedure is introduced after the start of the voluntary out-of-court liquidation. So the procedure is usually introduced for 7 months. So in this procedure, the debtor remains in possession, in full possession. The court appoints an interim insolvency practitioner, but his main purpose is to obtain documents about the debtor, to analyze the reasons that led to financial problems, prepare for the first meeting of creditors, maintain creditors' register, and participate in court hearings to include claims in the register. Management can be removed and an interim insolvency practitioner appointed only in exceptional cases related to violations of obligations to provide information, commit bad transaction, etc. The debtor continue his activity with some restrictions on making obviously unreasonable transactions, but it must be said that an important consequence of the introduction of this procedure is the suspension of payments, moratorium, and enforcement proceedings. This procedure has always been in the legislation. As part of the current reform, it will be rejected. But this procedure, which includes the role and the position of debtor in fully possession, can hardly be called special restructuring, because creditors and debtors are not deprived of the right to negotiate and conclude an amicable agreement, for example. so this is this does not have the essential feature of the restructuring procedure. Of course, the debtor in possession can offer to negotiate any plan, but the creditors, there are no any instruments for example, cram down and so on. What are the features of real restructuring? So I want to say that the debtor in possession not always can decide the aim of restructuring. Concerning the role of management, of directors, of the creditor in possession. You know, I tried to understand what the American law, I mean the Chapter 11, and says about the role of the management. So regarding, I would like to refer to American reasoning of Chapter 11. There is a report of the Commission to study reform of Chapter 11 within American Bankruptcy Institute, which is also analyzed in the ELI instrument. As part of their decision, the Commission also agreed that directors, officers, and similar managing persons who operate a business should remain subject to their state law fiduciary duties. This is due to the peculiarity of American corporate law. But interesting, there are specific state-level court approaches. In some cases, it is recognized that directors should act in the interests of creditors. For example, this is a citation. Debtor in possession is a fiduciary of the creditors and, as a result, has an obligation to refrain from acting in a manner which could damage the estate. While in others, it is the opposite conclusion, that the relocation of their duties, I mean duties of the management, should not transfer from the company and shareholders. For example, another citation. Corporate property is not held in trust. Creditors have the right to be repaid, but it is equally true that they do not have the right, absent an agreement to the contrary, to dictate what course of action the directors and officers of a corporation shall take in managing the company. So all these cases about debtor in possession. The debtor in possession model was expanded by Chapter 11, but it was the other form, not Chapter 10. So we see that debtor in possession restructuring framework for distressed business opposes to the creditor in possession options of voluntary administration and liquidation. Why I think that this is important point of view, maybe it's enough theoretical, but the management duties and the fiduciary duties and other duties are the point of importance in the process of restructuring. In my point of view, the debtor in possession, if we go to the restructuring, has to have autonomy to decide what to do, and all the directors. Because if we have the contract, which may be the plan or amicable agreement on some other forms which every country may have, there are at least two parties. The first party, of course, are the group of creditors. And of course, there is a problem to decide and to get the solution for them. But the main point is the contract between the group of creditors as a community of creditors and the debtor. And the debtor will have all the rights and obligations to offer the plan, to realize the plan, and if there will be the fulfillment, enforcement in good faith, the creditors can't intervene in the activity of debtor in possession. there is a problem. Sometimes in economic literature, it is called the problem of incomplete contracts. Why the creditors should go to the contract and to decide that they want to be the part of this restructuring procedure. But it can't be done by the means of transfer of estate and the subject will, the party will of the debtor in possession to the creditor. If the creditor goes to this way, this is a liquidation with all these principles. And in this case, all the estate and all the property in the course of pari passu will be redistributed by special means. But debtor in possession has to have the right to act in its will. There are problems for the creditors, which are lack of trust, asymmetric information. But there are ways to solve this problem, including in restructuring way of proceedings. They are information disclosure. Yes, of course, debtor in possession will need to give more information for the creditors. Additional control by insolvency practitioner. Participation of the court, including the ability to quickly apply to the court already with the framework of a restructuring procedure. And in the end, the participation, for example, of independent director in the board of directors, for example, in debtor in possession. So these are the corporate means which help to decide the problem of contracting. This aspect of the issue allows us to solve a number of restructuring difficulties. It seems to me that these are different sides of the same problem. However, forced redistribution is not the only way to solve the problem. And the forced distribution within the liquidation framework is not restructuring. So I think that there are two ways of deciding the restructuring. First, debtor in possession as an autonomous party of restructuring relations. And the second, the special means to control the activity and the means to go to the court.
Mr. Zadorozny, sorry to intervene. May I ask you to come to a conclusion, please?
Yes, of course. So my conclusion, maybe the main idea is that the debtor in possession is a key point of any restructuring, and the management of the debtor in possession has the duties before the company, of course, within the strategy of distressed company with a distressed situation, but still it needs to act in the interest of company, of course, transferring the interest of creditors, but not legally. Thank you.
Thank you, Alexander. And I think it just shows how much there is to tell about this topic. Luckily enough, we also have another topic where there's much more to talk about. So I'll be handing over the floor to Stefan, but before just adding, if there are any questions, please drop them in the Q&A. I see some questions already popping up. We'll be addressing them at the end, but Stefan, please take it on from here.
Thank you very much. Yeah, I'll have the challenge to host an even at least as interesting and complex topic in just as little time. So we will see how we'll cope with that. The second topic we cover today is the question how to deal with small, even very small businesses in their insolvency or distress. This comes from the background that traditionally, until like 5 years ago, insolvency law and insolvency legislation tended to look at the firm they had in mind as a medium-sized firm, as a standardized, more or less medium-sized firm. But if you look at the range of companies and businesses that may become insolvent, the range starts from the sole entrepreneur and ends somewhere in the multinational corporate group. So there's a lot that the standard model didn't cover. And we have addressed at least the larger spectrum already with multinational groups and especially UNCITRAL's Modular on groups. But the focus has never really been on the smaller, at least not as much as they deserve, probably because they might not be rich or asset rich, but they are many. And this is why they deserve our interest. And there has also been a perception that because there is not much to gain from small business insolvency, it's more a problem for the entrepreneur than it is for the business if they become distressed. So why not simply solve it by liquidating the business and maybe discharging the entrepreneur? That has changed. I mentioned that there has been research and a lot of initiatives from standard setting organizations within the past 5 to 6 years. We have, for instance, an academic group sponsored by the International Insolvency Institute that published the green book you see behind me on the modular approach of micro and small business insolvencies. We have the World Bank just updating the World Bank principles with a specific look on micro and small businesses. You already see the difference. It's micro and small, not small and medium size anymore, which is a significant shift in focus. We have the IMF publishing a report on the specific treatment of small businesses, especially in the fallout of the pandemic. And we have UNCITRAL, who is the UNCITRAL Working Group 5 that is currently about to finish a project on simplified insolvency proceedings for small businesses. So there's a lot happening in this area, at least with regard to standard setting, maybe not as much already with regard to actual legislation. I'd like to highlight, however, that the US is a good example for maybe a hard law already on small businesses that was introduced in 2019. So today we will quickly look into two things. I first welcome Edith. Edith Meurach is a professor of international commercial law at the University of Nottingham, and she's been with the UNCITRAL Working Group 5 on insolvency law since, I guess, 2006, if I read it correctly. So she's been involved in many projects, including the current project on small businesses. She was also part of the ELI sponsored academic group I just mentioned. So I welcome you, Edith, warm-heartedly, and give you the floor to present the ideas of those two groups on micro and small business insolvencies.
Thank you very much, Professor Stefan Madaus, and also Professor Bob Wessels and the ELI for inviting me to this conference, and especially to speak about this important topic. And indeed, it's encouraging, as Stefan mentioned, that increasingly issues related to the insolvency and restructuring of the small entities are taking more central stage and are higher on the agenda of, to some extent, domestic and certainly international standard setting bodies. And as also as Stefan mentioned, this is in contrast with the traditional typical focus on the larger entities. And Stefan mentioned some of the reasons for that. Perhaps I can also mention the fact that obviously the larger entities cases are more visible and more reported, and they create the precedence and the experience, and that in turn influence legislation. And so what we have argued in that book, in that green book behind Stefan, is that policymakers on the domestic, on the regional, on the international levels should almost force themselves to think more about the small entities, to think small first, and to try and create regimes, procedures that are tailored for the small entities, rather than trying to fix and adjust existing regimes, existing procedures to accommodate also the MSMEs. And so the idea wasn't to reinvent the wheel, but to use existing tools that exist in our system in order to create a wheel that is fitting the smaller cars. So using existing insolvency tools to create tailored regimes, tailored procedures for the smaller entities. And we called that regime that we proposed a modular regime, or a modular approach, because it is modular in two main ways. It is modular for the countries that may decide to adopt these simplified procedures. And so they may need to accommodate that modular regimes to their specific circumstances. So it is modular in that way. And also it is modular for the parties, mainly the creators and the debtors. In a particular case, in the specific country, using the regime, they may use different modules or different tools available in the system to fit the specific circumstances of the case. And that idea of creating a simplified regime that is tailored for the smaller entities is now reflected in those emerging international standards that Stefan mentioned, and in particular, the World Bank principles and the UNCITRAL forthcoming guide on simplified regimes for the micro and small entities. And Andres will talk about the World Bank principles, of course, and so I will focus on the UNCITRAL work, this forthcoming guide on simplified regimes for small entities. And I will just highlight 5 main ingredients or important features of this new guide, important at least in my view. So that new regime is simplified, but it is also comprehensive and balanced. It is comprehensive, and this is the first feature that I want to highlight. It is comprehensive in terms of the entities and the procedures that it covers. So the idea is that it applies to all small entities, whether they are individuals, partnerships, or companies, to any entity of whatever form that is small in the eyes of the country that implement the regime. And it is also comprehensive in terms of the procedures that it recommends or prescribes. And so the focus is not only on restructuring or only on liquidation, although the focus in recent years, domestically, regionally, internationally, has been more on rescue and restructuring, including in the EU, with the EU directive on preventive measures and on restructuring. It was acknowledged by the UNCITRAL working group that at least with MSMEs, many of them will not be viable and will need a simplified liquidation process that can result also in a quick discharge. And so both procedures are covered, reorganization and liquidation. The idea is to provide a simplified process that is sufficiently cost effective. Still, rescue in particular should be encouraged and facilitated for the small entities. And this is the second main ingredient in this new guide. And that is to encourage creators, but particularly debtors, to access the system, and in particular the reorganization procedure as early as possible when they realize that they are in difficulties. And to facilitate that easy access, one main way of doing that, and this is recommended in that new guide, is that the debtor will not need to be in actual insolvency or to prove that they are insolvent in order to access the regime. But at the same time, the regime is balanced in the sense that it aims to prevent abuse or manipulation of the system, of this easy access to the reorganization procedure. And so there are also tools recommended regarding cost recovery, conversion of reorganization to liquidation, conditions on discharge, and so forth. Fourth main feature linked to third key feature linked to the second is the concept of debtor in possession, which was also discussed at length earlier in the previous discussion. And so I will be brief, but this is also a measure to encourage rescues and encourage early access to the regime by debtors, because they know that they will remain in control. And so it is recommended in that guide that the idea of debtor in possession will be the default rule. So it is the assumption, the presumption that the debtor will remain in control. And this is also sensible because the debtor is the one most interested in the continuation of the business. And without the debtor, especially when it is a very small entity, usually there is no business. The debtor is the business, and so they should remain in control. But again, this is balanced by ensuring that creditors' rights are protected. And so creditors should be able to object to solutions suggested by the debtor. They should be able to require that the debtor is replaced, that they will not stay in control. And the debtor herself may request to be assisted, to be supervised to some extent in relevant circumstances. Fourth, and again linked to the third, continuing with this objective of protecting the rights of creditors, another key ingredient is ensuring meaningful participation of creditors and providing sufficient information to them, but at the same time acknowledging the specific circumstances, realities of small entities where information may be limited and where creditors may not be so interested in the process. They may be rationally passive. And so on the one hand, it is recommended that it will be required that debtors provide sufficient complete information and notices to the creditors about their solutions and about the state of affairs of the business, so that creditors can make rational decisions. But at the same time, that information may be limited, producing it may be expensive, and so the system should provide some assistance to debtors in creating that kind of information, and also require more limited information compared to what is required of larger enterprises, and that could be based on simplified standard forms. In terms of agreeing on solutions, voting on solutions, that can also be simplified by allowing a more passive agreement rather than active voting. And so the notion of deemed approval is also recommended in the guide, whereby instead of having an active vote, the creditors can receive, again, sufficient information about the solution proposed, and they can object to it. But in the absence of sufficient opposition, the debtor can go ahead with their plan. Finally, fifth key ingredient is with regard to the institutional setting, and in particular, the institution that is supposed to supervise or oversee the process. And the question is whether it should be the court or another administrative body. And the answer is, and this is reflected in the guide again, is that it depends on the system and which authority available or that can be created in the system will be the most cost-effective and helpful for the SMEs cases. And that may not necessarily be the courts. Courts are typically overburdened, and so it could alternatively be some form of administrative body. But if this is not available in the system, or if it is difficult to create such an institution or authority, then it could be the courts. But the court's function and role may be more tailored, again, to the small entity cases, requiring less information, employing more sort of stricter or simpler procedures, and also assisting more the parties, the creditors and the debtors during the process. Thank you.
Thank you, Edith. Very interesting and perfectly done in a nutshell, so to speak. Very well done. Now we have a look, we switch over, as you just mentioned, to the ideas that the World Bank just published in their updated principles. So I'm very happy to see Andres here. Andres Martinez is, and now I need to read it, a senior financial sector specialist with the World Bank Group. Andres was with the World Bank, or has been with the World Bank since 2008. He has advised several countries on debt restructuring, law reform. So he's very experienced with experience on the ground. And he's one of the authors of the updated principles, and therefore perfectly fitted to give us another overview in a nutshell. Please, Andres.
Well, thank you, Stefan, for the kind introduction, and special thanks to the ELI for the invitation to the World Bank to participate here. It's a pleasure to see, read, and share this panel with Professor Memorak. So, and to present to all of you. I'll try to be as to summarize as much as I can. I think it's a very fascinating topic. I'm sure that, I mean, it's been said that the World Bank Group as a joint standard setter with UNCITRAL, we work in quite a few countries. We started paying attention to micro, small, and medium enterprises initially, simply because they're absolutely critical in all countries. I think, Stefan, you mentioned not only that there are many, but also they employ a lot of people. They have a very, they have an absolutely critical role in poverty reduction and financial inclusion and everything that we really look at from the financial sector standpoint. So I think the identification of the problem, and I'll echo the kudos to the Green Book that you guys published, which was indeed one of the key sources that we looked at. Obviously, the World Bank as standard setter has to convey the task force and discuss, and that's the whole process that we took when embarking on these updated principles. It took us 5 years because we first started looking at this in 2017. But I very much enjoyed the discussions with you, and I think you definitely contributed to this process quite a bit. So I wanted to echo the Green Book shout out. Going back to the issues, I mean, I think as a standard setter, and this is the only caveat that I will make today. I promise you. So I was trying to set my watch to make sure that I don't run over time. A standard setter, we are extremely conscious of avoiding dangers of setting standards that are overly skewed towards resource-heavy implementation requirements, right? So this is something that for us is absolutely paramount. So we are conscious that what may work for some countries may not work for others. And given that I'm speaking, I guess, to mostly a European audience, it's important to bear this in mind, and that's why I make the caveat, right? So some things we work quite a bit in Africa, quite a bit in Latin America, and some things that may work for Europe due to the sophisticated institutions that Europe has as compared to many other countries we work in, may not be applicable, right? So that's something that we always keep in mind as standard setters. Let me take a couple of steps backward, because I think it made an absolutely great job in summarizing some of the UNCITRAL, and the modular approach, of course, solutions. But I want to take a step backwards and say, okay, but what's the problem here that we're trying to solve here, right? What are the challenges for micro and small enterprises and their insolvency? And I think that there are many that we identified back in the day, right? And I think this again goes back to something that has been done by all parties here. And I think it's first of all, lack of incentives to access insolvency processes. Micro and small businesses just don't know about it, don't care about it. And even if they know and care about it, they probably don't have the requirements. They would never be able to fulfill all the list of the checklist that insolvency laws around the world typically have, right? Audited balances for the last 3 years. What? I mean, issue of creditor passivity. This was mentioned by Reed. I mean, creditors just don't care about participating much in plans, and we'll come back to this topic, right? Limited information, accessing finance during insolvency is a major issue. The overlap between business and personal insolvency regimes. The other issue that we stumble upon in every single country we work in is the issue of insufficient assets to fund insolvency processes. This is something that, again, the no asset cases, or so-called no asset cases that clog courts very often need to have some sort of separate treatment. This is very linked to micro and small enterprises, right? And what about medium? That was the discussion that took us a couple of years to resolve, to take medium out. There are many reasons. Again, I'm happy to discuss this if it comes up in Q&A. As I said before, we started working on the report on the treatment for SME insolvency in 2017. 2018, we looked at some proposals, and 19 and 20, we discussed with the task force. We finally launched the principles in April this year, and I'm more than happy to put them in the chat. What basically the principles do, and I'm very, very generalizing quite a bit here, is to make sure something that it emphasized quite a bit. It's convenient, inexpensive, easily accessible insolvency processes for micro and small enterprises. Critical. How to minimize procedural formalities. As we said before, checklists of documents that these micro and small enterprises need to file. We need to make sure that is simplified. Easy conversion, of course, from simplified to ordinary and vice versa, in case more creditors show up and so on. Approval of reorganization plans by majority of creditors. We kept that. We did take a step forward in saying that the implicit vote means approval. That is the step we took. Eliminating or requiring creditors to object to or to have a sufficient opposition is something we didn't do. We can discuss it separately. The reason is, as I was saying, we're conscious of not I mean, in countries where the institutional setup is not as strong, this may be interpreted in a way that may hamper creditors' rights. That's the way we saw it, and I think that's. But I think it's a major step to address creditor passivity to have the implicit vote or the absence of expression as an approval of the plan. Management of businesses by debtor, of course, I mean that was, again, as Edith said, very much expressed today, and discharge of good faith natural person entrepreneurs, something very much emphasized in the ELI report too, and in the EU directive of 2019. We concluded with some institutional considerations. I echo what Edith was saying. Perhaps courts are not the ideal venue to deal with these cases. So we did change some of the D principles, which is where institutions are contemplated. To me, one of the issues here, and again, this is purely from experience on the ground, dealing with law reform in many countries. I have seen in the majority of countries that I work with, judges not being able to pay attention to their large cases because they have thousands or dozens or hundreds of no asset cases that they need to deal with, and there needs to be something needs to be done to separate that, because otherwise you won't have judges, you know, or institutions, whatever, being able to deal with cases as they should. The issue of resources is obviously a completely separate issue. So let me finish here. I think I've been extremely conscious of time, but we have a nice Q&A session. We can have a separate discussion, and I'm more than happy to respond to questions even after this great webinar. Again, thank you, ELI, thank you, Stefan, thank you, Professor Wessels, and thank you, Reed, for the kind invitation.
Thank you very much. Excellent. And now I hand it over to my colleagues again before handing back questions, maybe, hopefully. Thank you very much once more.
Can Gert-Jan, we discussed the question. Can you pose a question to one of your colleagues?
Yes, definitely. And let me maybe pick up first one question that was already posted in the chat by Georg Wabel. I'll read it out. I think it develops on, I think, some questions that have emerged in German law, but they might be interesting to hear back how that is also the case in both France and in Russia. He's asking you a question on the debtor in possession. Should, in your eyes, the debtors, directors being in possession underlie the same duties and liability as a court-appointed restructuring expert or administrator would have in order to avoid a gap in creditor protection, also including direct personal liability towards creditors, ? So question to you, Helen and Alexander, is there a similar standard of duties and liabilities for the debtor as debtor in possession versus the court-appointed practitioner in both preventive proceedings and in insolvency proceedings?
Okay, I can start if I may.
Sure.
Just to say in addition that in France, there is no direct and legal connection between the fact that a debtor requires the opening of a pre-insolvency out-of-court procedure, a preventive procedure, and a discharge of any liabilities thanks to that. Meaning that even if he asks and obtain a preventive proceedings, it is not protected by a legal effect. It means that if the debtor or the manager is doing anything that could be reproached later, he will have to respond on that. Even it has been judged that it could be something that could be reproached to the debtor if the opening of the preventive procedure has only as effect to postpone a decision to file that would have been obvious and that could have been opened earlier and not later. Meaning that if the preventive procedure lead to lead to the company to stay in out of procedure only to hide a special situation, I don't know exactly why, it could be reproached. So it's true that it's something giving a good view, and it could be something appreciated to demonstrate that the debtor and the manager try to find solution. So it could be something positive, but by itself, it doesn't lead to lose any liabilities. In the other side, it's true that after the opening of an insolvency proceeding, reorganization or safeguard with still the debtor in possession, if it's a partial possession, it's true that the appointment of the insolvency practitioner in a way is exonerating the debtor of the own responsibility and liabilities. But it's only for the measures or the decision that could have been taken with the IP. If it decides to do something on itself, on its side, without sharing this measure with the one who it should have been shared the decision, the court, the judge, or the IP, judicial administrator, it could be something increasing his liability. So he has a duty to collaborate, and the duty of collaboration is something that is really considered at the time of the count at the end of the process. So I don't know if I was clear, but I tried to explain to you how it works in France.
Yes, thank you, and in great detail, Helen. Let's move to Alexander. How is that in Russia? Are there similar duties? Is it desirable to introduce something like that in Russia, if need be?
Well, some words about Russia. So the duties of the manager remain standard, but there are, of course, some special scope of duties which reflect the status of debt in possession. The first, it is the information duty. So as I said, the main duty of the director of the manager concerning the interim international practitioner, insolvency practitioner, is to give all information and documentation about the company, so the insolvency practitioner could analyze to get information about the activity of the company. So this is the new duty. And maybe the second, but it is the same for the period of out of court, pre-insolvency, any duties of directors. It is to go to the court, to the duty to file in time, to file about the bankruptcy. So I would say that I think that these duties are standard, and no special duties for directors and for debt in possession we can find in the current Russian legislation.
Okay, thank you, Alexander. I think that answers the question received in the chat. Stefan, did you want to follow up on this as well?
Sure, why not? I'll use the opportunity, and if no one else is interested from the audience, I can pose a question that I'm interested in. One of the key elements was, of course, to which extent can we make creditors of small businesses accept a plan that, of course, foresees that the entrepreneur remains in control of the business after the plan is accepted. So, to put it more bluntly, creditors get a haircut, and the debtor remains in control of the business, not only through the proceedings, but also after the proceeding. The question would be to the both of you and the respective framework, of course, which safeguards are applicable there? Is that possible? If creditors remain sufficiently silent, do you need a certain majority? What if, you actually need a cram down, but maybe we don't even need to get there? So is there something that needs to be fulfilled? Is the US law an option where you simply need to put up the projected disposable income of 3 years and you're good to go with a plan? So how are your feelings about that? Edith first, maybe.
So as you know, Stefan, in the book, we did think that this is a good innovative idea to consider allowing this kind of solutions where the debtor will remain in control, remain shareholder if it's a company, etc., and creditors will be crammed down to some extent. To say that, to note that in UNCITRAL we didn't agree on this level of detail. So we didn't disagree with this concept, but didn't reach an agreement on this level of detail. So we sort of left it to domestic regimes to apply the concept of a plan, for example, in terms of the voting mechanisms, except that we do refer to the notion of deemed approval, for example, but what will be exactly the threshold for voting and what can be received by whom, this is left to national legislation. Probably in commentary, there will be a mentioning of this idea of cram down in the US approach, but it is not a recommendation as such, not because it isn't recommended, just because we decided not to agree on that level of detail.
Thank you. That's, a good insight into UNCITRAL's way of working, which is lovely when there's consent, and which is useful if there is none. Andres.
Let me take the question. It's a very complex question because it has too many pieces, right? And let me respond from a completely different angle, right? I litigated for 7 years before joining the bank, and I worked in many restructurings in which mostly creditors had lost trust in the management. So being imposed a plan that where the management remained in control without the opportunity for voting would have been not desirable back in the day, particularly during a crisis where the number of cases was increasing. Now, going to our standard setting work, we have to be mindful that there's many jurisdictions in which the institutions are not as strong as to properly trace assets that were deviated, for example. So I'm not going to talk about fraud. We should never legislate thinking of fraud, right? That's totally out of the question. But we have to be mindful that whatever works for countries that have the tools to undo these transactions, for example, or courts that are specialized to begin with, which is the luxury that the US perhaps can give themselves as having, the Southern District of, of New York in the bankruptcy courts, and many other countries, of course. In Europe, you have many. It's not something that a generalist judge in any country, you name it, in any emerging country that is dealing with a divorce in the morning, that is dealing with an eviction in the afternoon, and with an insolvency case, which is probably the one that they don't want to touch, right? Because of its complexity, that judge will be applying the law, right? And if you're on the creditor side, you get pretty uncomfortable in that position, right? Particularly the more flexibility, the more ample the mechanism is. It really opens the door for issues that may come up. So I think the question is complex because it touches upon two different things. On the one side, you have the debtor in possession, debtor remaining in control, and creditor and cram down imposition of the plan, which is two things that perhaps I would treat separately. And I think they are, even though they are very much related, I think the plan contains many important things, the management being one of them indeed. But thanks for the question. That's very good.
Thank you, Andres. Yeah, it's difficult as usual, but I hope we can come up with solutions that work for small countries as much as more industrialized countries. And just to finish with an anecdote, many of the German insolvency judges are part-time insolvency judges too. So they do family cases in the morning and insolvency cases in the afternoon. And the outcome is sometimes, not always, but of course, but sometimes similar, more or less the same. Thank you.
Yeah, it's a matter of number of cases too, Stefan. Yeah? It's a matter of number of cases. So the emerging countries that I'm talking about is the single one insolvency case, or perhaps it's just a bunch of them, not the number of cases that you may have in sophisticated jurisdictions, right? That's that important matter for specialization, I mean.
Well, thank you very much for the two interesting topics. allow me also an anecdote. You see the beautiful room where Stefan is sitting. If you're a Dutch professor, you have a room like 1 square meter or 2 square meters. But the guy has a room of 4 by 5, and we worked there for 3 or 4 days to finalize our report. I think it was about 4 years ago, and I still cherish the moment that we worked there. What we touched upon today was the debtor in possession, which is in many Europeans a rather new concept. And that for France, there are some rules, but for the other European countries, many of them, they will have to create rules. And as a matter of fact, July 21 was the time limit for the implementation of the directive. But I think some 18 or 20 countries have asked for a year of postponement. So it still takes a while. The other topic is also discussed in the European Commission. We talked about it for over an hour, try to also convince the European Commission that it should come more strongly on the political agenda of the Council, of the representatives of all the member states. So we hope that the discussion also can help Europe and the European Commission to take notice of the developments of the World Bank and UNCITRAL, and preferably also to our recommendations related to this subject. Well, the impact, I told you about short notice impact, but on the longer run, national insolvency laws, they don't change overnight. And I'm young enough to know that sometimes it takes 8 or 12 years before a certain concept finally comes into especially civil law loving countries. So I think our report can still play a role when over the years, insolvency and restructuring law has to change. Secondly, the European Systemic Risk Board in April said something like, if the governments are easing down of giving finance to all the enterprises that are in a standstill, there will be probably a tsunami of insolvencies. So I think also in the longer run, our report may play a role on European level or for national legislators looking for solutions and trying to sharpen their mind based on our recommendations. And thirdly, I'm involved far away at the Asian Business Law Institute. And what you see there is the growing need for financial integration in many countries in Asia, but the laws in all those countries are very different. And there, I think in some 5 or 8 years, you may expect that there will be principles for business of restructuring. And I've sent an email to Gert-Jan that he can link something of a publication with regard to Asia and business restructuring there. I hope I said in the beginning that there will be a video available of this discussion, the presentations, in a few weeks. If you want to remind a colleague that that has been discussed, please go ahead. I would like to thank all our guests and my fellow reporters and the staff of European Law Institute and you as the audience that you gave attention to us. Thank you for your interest, and I hope personally that I can meet you live and shake hands anytime soon. Thank you very much. and see you soon.